We've got a great show for you all today with repeat guests, a rare China Talk honor, DOJ National Security Division attorneys Lee Licata and Devin DeBacker. We're recording this show around lunchtime, Election Day, November 5th. So, of course, our topic today is what's on everyone's mind, the DOJ's new proposed rule on data security. For more of China Talk's coverage in the run-up to the election, we've got naturally best of Chinese hip-hop and rap, best of Chinese shoegaze, and most importantly, who's the best Chinese AI boyfriend? But today we'll stick with DOJ data security rules. Lee and Devin, welcome back to China Talk.
Happy to be back. Would honor come with an award or a plaque of some sort?
You know, I'm not in charge of funding here. Jordan is the dictator of China Talk, but your request, like I'm sure the many requests you received in the notice and comment period, is duly noted. So for those who missed the show back in April, basically, there was this February executive order on preventing access to Americans' bulk sensitive personal data and U.S. government-related data by countries of concern. And then we had this advanced notice of proposed rulemaking, ANPRM, and today it's a notice of proposed rulemaking, not advanced anymore. Presumably the next step is a final rule. But what's a 40,000-foot view of this executive order and the proposed rule? And what kind of national security risks do they seek to address?
I'm happy to take that one and glad to be back. So for folks who missed the spring show or who are just wondering, really what is this? What are the 422 pages of regulatory detritus getting at? Look, the main risk that we're concerned about are the national security risks that exist when a foreign adversary, like its intelligence services or its government, can get access to sensitive personal data of Americans. They can take that data, they can exploit that data and weaponize it against our national security interests. And they can do that in a number of ways. You can take things like geolocation data and track and surveil Americans. You can take personal health and financial data and use it to look for vulnerabilities in people's lives, their vices, their patterns of life, and their day-to-day activities, and exploit that understanding of their habits, either at a micro level, looking at individual targets, or at a macro level, looking at sort of aggregated insights that you can get from populations. And you can take those insights and turn them into weapons against our national security. You can track, surveil, blackmail, coerce, intimidate, influence, and a whole host of other verbs, folks on whom you have that sensitive personal data. And that's really at the core of what we're trying to address with this rulemaking.
So this rule, it's not addressing, I don't know, for example, some intelligence agency hacking in through the back door and stealing information. You're talking about just data that's, for example, on the open market that could be purchased by anyone. Is that right?
That's exactly right. And so I think the front door, back door, side door analogy is the right one, right? We've got a barn full of data and what we're on Americans. And what we're trying to do is close the front door with this rule. There are other, mechanisms and tools and efforts that DOJ in particular, but other agencies are involved in closing the back door. But the key is we can't leave any of the doors open, right? And for a long time, the front door has been wide open, and in some ways wide open and advertised as a free-for-all. And that's the front door that we're trying to close with this rule. To put it in more legalese, the legitimate or lawful commercial transactions that foreign adversaries can engage in, buying data on the open market, accessing data through vendors and employees and investors that come from those countries or that those countries can otherwise leverage through their political and legal systems.
So where do you locate this rule within the overall sanctions and export control universe? And how do you see a rule like this one contributing to broader discussion between the interplay between national security and economic security? How similar or dissimilar is this kind of regulation to famously the semiconductor export controls?
Sure. So I'll jump in on this one. There's a lot of flavors in this rule that look a lot like OFAC and like our export controls regime, right? In many ways, this seeks to move us away from the case-by-case approach we see in places like CFIUS or Team Telecom, or even to some extent the Commerce ICTS Authority that may look at a specific commercial transaction or a specific foreign entity, and to be more of a sort of systemic or holistic approach that looks across holders of this kind of data, right? And so the idea was to have this look kind of like an OFAC regime in putting these prohibitions and restrictions in place. And so it has many of the same features, things like advisory opinions and licenses that are hallmarks of those regimes. But ultimately, we see this as a good first step moving us to that more horizontal approach.
And to just add a more zoomed out view, at the end of the day, there are things we care about. There are there are assets or national security assets that we care about in the United States that we don't want to end up in the wrong hands. Sometimes that's technology. Sometimes that's just capital, right? We don't want money flowing to terrorists and to other places. Most recently, with outbound investment, we don't want not just money, but money and the know-how that comes with it to flow to certain critical sectors of emerging technology. And we also don't want American-sensitive data flowing to the wrong hands either. And each of those regimes deals with a different part of that problem. Right? Export controls is primarily about the technology. Sanctions is about the capital. Outbound investment is about, well, outbound investment. And of course, our program is about the data. So it really is a part of a suite of authorities in our toolbox.
Okay. Yeah, let's move to specifics now. If anyone's reading this rule, they'll basically see a phrase like, the rule says a U.S. person cannot engage in a restricted transaction to a covered person. So what is a U.S. person and a covered person, and what exact transactions are restricted?
So that's right. There are certain kinds of covered data transactions that U.S. persons, at its core, the program says there are certain categories of covered data transactions that U.S. persons either can't engage in or they have restrictions on how they can engage in them with countries of concern or with covered persons. And since Lee is the architect of many of those elements,
Sure.
I'm going to let him go through each of those.
Sure. So first, let's start with what's prohibited, right? There's two types of commercial transactions that we prohibited between a U.S. person and what we call a country of concern or covered person. Those are data brokerage and certain commercial transactions involving the transfer of genomic data or what we call biospecimens, which is the raw material with which genomic data can be derived. There's also three sets of restrictions. Those would be vendor agreements, employment agreements, and investment agreements that are not passive. And with the restricted agreements, as Devin said, we're really trying to put a box around how those transactions are conducted. And what I mean by that is we basically tied them to a set of security requirements to say this transaction could go forward as long as certain types of security are put in place to prohibit a country of concern or covered person from accessing the data at issue. Those security requirements were issued by the Cybersecurity and Infrastructure Security Agency at the Department of Homeland Security in a concurrent Federal Register notice that was released at the same time as our proposed rule. But they cover things like organizational security requirements, having a security officer and a security policy, system level security requirements, having the ability to put physical or logical access controls in place in your system around data, or data level requirements for security. Those are things like encryption and anonymization techniques or data masking techniques, right? And so what you have is the sort of the straight prohibitions along with these restrictions that we put in place. Now, in terms of who are the covered persons and countries of concern, we've got 6 countries that we've designated, and they're the same as the ones from the advanced notice of proposed rulemaking. So China, Russia, North Korea, Cuba, and Venezuela, and Iran. Covered persons, we have 4 buckets of covered persons. So for example, they're entities that are headquartered in or owned by a country of concern. They're entities that are owned by another covered person. They're entities or individuals that work for a covered person or a contractor of a covered person, or they're individuals or entities that predominantly reside in a country of concern. And then there's also this 5th catch-all bucket, which is, anyone the Attorney General determines to be, acting at the behest of a country of concern, essentially. So think proxies and cutouts and shell entities, right? And so, as I mentioned, you have this kind of OFAC-like structure that we're putting in place here.
Yeah, lawyers always put in the catch-alls at the very end of statutes. I would expect nothing less from y'all. What exactly does this rule's compliance and enforcement regime look like? That was one of the big value adds of this rule. What should companies be thinking about as the DOJ works to finalize a kind of rule like this? I mean, I see due diligence obligations, a licensing regime, annual reports, even requirements to disclose when a U.S. person is solicited with, but then rejects an opportunity to transfer restricted data to a covered person. Just, can you describe what is DOJ's enforcement mechanism actually going to look like?
Sure. So first, what we really want companies to do right now is to consider filing a comment on the docket while we're finalizing the rule. That input's really important for us to understand how this will be implemented and what the impacts might be.
And the more specific, the better.
Right.
It's helpful when we understand the specific kinds of transactions companies
Correct.
are engaging in, so we understand how they think it's going to apply under the rule and see if that matches our understanding so that we can clarify things as needed.
Correct. And the comment period ends on November 29th. So it's a 30-day comment period that began last week. That's what we're really looking for. But more importantly, what we want companies to do is to start to orient themselves towards what their risk profile looks like with regard to these rules. So what are the things we want them to know, right? We want them to know what kind of data they have and whether it's some of the types of sensitive data that's regulated here. We want them to know what sort of commercial transactions or relationships they have that may involve a covered person or country of concern. We want them to know who has access to that data from a country of concern or covered person that may be subject to these prohibitions or restrictions. And we want them to know what kind of security measures they have in place to protect that data. And you mentioned, the compliance and enforcement regime. So, like I said, it borrows from a lot of the export controls or OFAC flavors. So you're talking about things like record keeping requirements. You're talking about annual reporting requirements. You're also, as you mentioned, talking about reporting rejected transactions to us, which is, a concept borrowed from OFAC sanctions. You're talking about auditing requirements for the restricted transactions to ensure that the security measures are appropriately deployed to protect data. And then you're also talking about, for example, having certain policies in place to ensure that these entities that have the data have some governing set of principles around how they're complying with the rules that we're putting in place. And then finally, I'll mention the rule talks about the enforcement component, right? So this is an IEPA-based executive order. And so DOJ gets to avail itself of the IEPA enforcement tools. That includes both criminal prosecution as well as civil penalty, right? And so you'll see the rule lays out things like the thresholds for a civil penalty when we find a violation, for example. It also includes things like the ability to identify and notify of a violation even when there's not a financial penalty, but we want to make sure an entity knows they've done wrong, for example. So all of that is contained in the proposed rule, but it's really about orienting entities that have this data to what their risk exposure is.
And to take a step back, the thrust of the compliance approach here is, as Lee said, similar to sanctions. And what I mean is, for most of the kinds of transactions for many of the kinds of transactions under the rule, companies are going to have to develop an appropriate in-house compliance program that takes account of their particular risk profiles for their company, right? Depending on where do they do business, who do they do business with, what kinds of business do they do, and so on and so forth. And that's going to vary company to company. Now, there are some affirmative requirements that Lee mentioned when it comes to the restricted transactions, since those are in some ways higher risk transactions we're allowing to go forward under certain conditions rather than prohibiting outright. But I think, look, our posture when it comes to compliance and enforcement is compliance first, right? Compliance is always the best solution. And it really matters because we've seen, you know that corporate compliance, especially in the national security space, is a real priority for DOJ. And we've seen in other instances where companies have to be our partners, right? They're on the front lines. They're the ones who actually hold the data, or in export controls, hold the technology, or in the sanctions regime, have the capital, right, that we're concerned about. And so what we really need in the first instance is a partnership between us and companies to make sure they understand their obligations and make sure that they can implement good compliance programs. But look, we're also DOJ. And so we're also going to not shy away from our enforcement tools. I mean, at the end of the day, what really matters is not the beautiful 422 pages of proposed rule and what the words on paper say. What matters is how those words bear out in real life and whether or not they actually protect against the risks we're concerned about.
Let's say I'm company X and I read this rule and I think, oh my gosh, this is going to be massively expensive. I don't want to do yet another compliance regime in my company. How is DOJ actually going to know if I violated the rule or not? I don't know. Can you even give that stuff away, or is that DOJ trade secret compliance land? You can't get into that.
I would be pretty sure that we're going to find out. And I think that's for a couple of reasons. One, corporate compliance is our bread and butter. And it's particularly our bread and butter where this program is housed, which is in the Foreign Investment Review section that I'm the head of. We have a whole separate standalone team that does nothing except compliance and enforcement every day, midnight to midnight, round the clock, nothing but compliance and enforcement. That's their whole job. They do that for some of the other national security authorities that we're responsible for, or that we're a part of, like CFIUS and Team Telecom. And they do it for these exact kinds of data security measures. They just do it in the context of a different authority. So we've got a really well-steeped team. We also have the FBI, which is pretty good at investigating these sorts of violations, right? Whether it's, they do it for sanctions, they do it for export controls, they do it for this. And so we've got our law enforcement and our intelligence tools to investigate. We're going to have tips from the public, of course, that'll be a mechanism to get information. We've got these reporting and record keeping requirements. Some of those reports will come in. We'll review them. They may lead to follow-up questions. We may see things that we need to investigate as a result of those. Also have the record keeping requirements so that if we know that there are particular companies that are at a higher risk or have a higher risk profile, we can visit with them and we can inspect their records and do a sort of books and records inspection to make sure to see how are they interpreting their compliance obligations, and are they interpreting them the same way we are, or do we need to have a conversation? And I think we just have a variety of tools at our disposal that we'll be able to look at. And I think the other key part here is that one person can't engage in a transaction, right? So there's always at least two parties. If we don't find out about it from one of them, you can be pretty sure we're going to find out about it from the other one.
Well, industry, you've been warned. And from what I've read, you engaged in a ton of industry feedback and public engagement. There was this little nugget early on in the notice of proposed rulemaking. The department also discussed the order and contemplated regulations with stakeholders at events open to the public, including ones through public engagement such as ChinaTalk, etc. So free publicity to fellow podcasters. If you want good press for your outfit, go talk to DOJ lawyers. You'll want them on your side. But yeah, there were 114 questions in the DOJ's ANPRM. What were the biggest changes made to the rule as a result of these comments and other engagements?
Sure. So as you said, we got about 70 comments to the ANPRM during the comment period. And in addition to that, we met with more than 100 different organizations, companies, trade associations, civil society members, academics, all of the regulated community that we could engage with during the comment period to try and get feedback about, how this proposal would work in the real world. And, based upon that, we got a whole range of feedback. But we'll start with what we didn't get, right? No one told us the internet was going to break by putting these rules in place. No one told us that the economy would collapse, right? But what we got were a lot of acute policy issues that needed our consideration to ensure that the rule was implementable and that we didn't have unintended economic consequences from putting this in place. So what are some of the new things? First, there's a few important features of the rule that'll help orient folks to what this program's about. So, for example, we include an analysis of the 6 countries of concern and why we've chosen them, an unclassified record that lays out what the concern is we see with those 6 countries. We provided bulk data thresholds for at what number a data set is considered to be bulk, right? And with that, we provided an analysis that looks at human and machine characteristics of data to explain, why we think an adversary is interested in this data and how it could be exploited. So to give you a quick example, variability. Geolocation data is variable in the sense that as a person moves with their device, that location over time will change, right? Whereas genomic data doesn't ever change on the individual. So we show how we make that kind of assessment. Finally, like many significant rules, we've conducted an economic impact assessment that lays out what we think this costs. And it borrows from, studies that look at things like GDPR compliance, other types of due diligence activities, and it puts together an annual cost assessment for the rule. So that'll help orient people towards what's in the document. A few new substantive things. As I mentioned first, we set actual numbers for those bulk thresholds, and those range from 100 for genomic data all the way up to 100,000 for certain types of personal identifiers, right? But those numbers increase as the sensitivity of the particular type of data to an adversary decreases. Second, we've added some new exemptions based on the public feedback. So for example, for telecommunications services, to ensure, for example, that a roaming agreement can occur when someone travels to a foreign country, that they can use their device and personal identifiers can be shared back and forth without running afoul of these rules. New exemptions for clinical trial data, for example, for an FDA regulated clinical trial in order to do the kind of research we need to create new medical devices and products. Additionally, an exemption for clinical trial data for submissions to a regulator in a country of concern, right? Pharmaceutical companies want the ability to sell their products in China. And in order to do that, they have to provide a clinical trial package that has some sensitive personal data in it. as well as for post-market approval surveillance and safety purposes, right? So we've created some new exemptions. We've also provided some further clarity around some of the existing exemptions that we were proposing, like financial services, to clarify the different sets of services that we're carving out to ensure that this isn't really an economic decoupling, hidden in the rule, as well as things like intra-corporate transfers, where we've listed out specific back office activities that, that we want to exempt. And then finally, as we discussed, we lay out all the C&E requirements, the compliance and enforcement requirements, some of which we had sort of suggested in the ANPRM, but we provided a lot more clarity around record keeping and auditing and some of the other things that we're tying to the compliance regime that we're setting up.
How do you think industry's feeling about this one? Like, is DOJ expecting millions of dollars spent on lobbyists who are going to go knocking on your door every day to try to create exceptions to swallow the rule? Or was your impression that industry is actually pretty receptive to this and you think there's going to be broad-based compliance going forward?
So we don't totally know yet, but what I'll suggest is this. The lobbyists seem to understand the concern we're trying to address, right? No one has challenged the assertion that adversarial nations are seeking to acquire American sensitive data and that this is a very real national security issue. I think that they're certainly trying to understand for the industries they represent what this means for them, right? And what are their compliance obligations? And what are they going to have to know about the businesses they run and the commercial transactions they undertake? I think that, from what we saw in the first set of input, it was helpful to see, as I said, acute policy issues that we really needed to consider and determine how they fit within this framework, right? Well, like I noted, what we didn't hear was that this was going to, sort of crumble the democracy by us creating these rules, or that this was going to have, drastic impacts that are unanticipated. And so that does suggest to us that industry stakeholders are kind of understanding that they will have to comply with this and starting to understand what their risk exposure is. Doesn't mean they're not going to advocate as strongly as they can for the industries they represent, but we found the input to be fairly helpful.
And we've been, just like we did with the advance notice and the ANPRM in the spring, we've been doing a lot of public engagements, even during this period as well. I mean, we're really looking for broad-based feedback, including feedback from folks to say, if they say, well, it's not going to work in this context with respect to this transaction, or this kind of activity is a little bit different, and so how does it apply here? Things like that. And so I think we've already met with, we met with over 100 in the spring. I think we've already met with over 200 in the short period that the comment period has been open. So we're really, we're not saying no to any meeting request, right? Yep. When it's a wide cross-sector approach to engagement. So, our ears are open.
Maybe this might be too in the weeds for just a nerdy law student, so let me know if I'm off base. But there was this one line in there. Several commentators suggested revisions to borrow or incorporate aspects of international or state privacy laws into this proposed rule. But then DOJ says, nah, because general privacy protections and national security measures have different objectives. So what precisely were those aspects of privacy law, and why did you take the approach you did in this role?
So I'll give you two quick examples that I think are helpful. So the first was around the definition of precise geolocation data, right? So most state privacy laws will define precise geolocation data using a distance of 1,850 feet from the device, right? And that's kind of become the standard in various state laws. But devices aren't actually set up that way, right? So to calibrate precise geolocation data on most major operating systems, you either have the choice of 1,000 meters or 10,000 meters, right? So we chose 1,000 meters because we think that actually correlates to how this information is collected from the device. And that's actually what allows you to potentially identify where the device is, right? And so we wanted to make sure that was sort of consistent with what we see in technology. The second one I'll give you an example of is around the definition of PII, right? So state privacy laws generally cover protections for all PII, right? To include the kind of data about a person that's found in the phone book, name, address, phone number, much of which is already publicly available. And our goal has never been to regulate the phone book. More importantly, it's to think about what an adversary could exploit that isn't publicly known about you. So you'll see in our buckets of sensitive personal data, we've come up with a narrower construct called covered personal identifiers, which looks at certain things like combinations of a name with a social security number or a passport number or other government identifiers, or even like device identifiers like an IP address or a MAC address, right? In combinations that we think would allow you to identify an individual based on those two pieces or multiple pieces of information together. But it's a departure from the privacy law construct, which just looks at PII as a broader category. It also, to the point you make about, the goal of privacy law versus national security, which is that, like, when you're thinking about, these sorts of, combinations of data, our goal here was to be very narrowly tailored to this specific risk. Right. And so that tailoring has resulted in a much, much more consolidated concept in terms of covered personal identifiers. And so that's where we've made those departures. But again, we've tried to, in the rule, explain what our thinking was in doing something different.
I'll give you another example as well. I mean, a third example, because the best things come in threes, is this idea of a consent-based exception, right? So one suggestion that commentators had was that the rule should incorporate an exception for the cross-border transfer of data when the person on whom it's collected consents to it. And I think that is a good example that really highlights the difference between privacy law and national security law, at least as we see it. From a privacy law perspective, what you're concerned about is the individual right of the owner of the data to control the usage of that data. Then a consent-based exception makes perfect sense. But if what you're concerned about from a national security perspective is the way that individuals and companies' choices might create an externality, a cost to our national security, then it doesn't make as much sense to include a consent-based exception. So you see that reflected in the rule. I mean, if you think about, for example, export controls, we don't have a consent-based exception for export controls. We don't say, well, technology can't flow, some sensitive technology can't flow to Iran or North Korea, unless the company that made it said it's okay, because that wouldn't make any sense. So I think the bottom line here is that we see privacy and national security in this context, in the context of protecting data, is very complementary. You're not going to solve all of the problems or all of the challenges associated with data in our digital world with one tool or the other tool. They really, they both serve just different objectives and different functions.
One more technical question, perhaps, about the rules. Data, unlike semiconductors, can move around super easily. You can have satellites, undersea cables, whatnot. So let's say U.S. company A sells to company B, which sells to company C, which is in some third country. And then they sell to a company in Venezuela or Iran or whatever. And then it ends up in the hands of some adversary. How does this rule mitigate against these kinds of risks of transferring data legally to a third country and then that person selling it to someone we didn't want to have the data in the first place?
So I think there are two aspects to this. On the one hand, as Lee said, we want to make sure that the program is targeted and balanced in how it approaches the obligations on U.S. companies. And so we don't have, for example, set aside some sort of evasion or structuring of a transaction or something like that, like a shell company. Setting that aside, we don't have any what we call pass-through liability, right? What we don't say is that a U.S. company selling to, let's take sale as an easy example, U.S. company A sells to foreign company B that has a vendor that's company C that has an employee that's person D, and the person D is the covered person. What we don't say is, U.S. company, you're responsible for looking through all the layers of the turtles all the way down to figure out if it's a turtle or an elephant, right? We don't say that. That's a really critical feature that we built into the program to make sure that it wasn't going to have those kinds of unintended economic consequences. Now, at the same time, sale is a tricky one, right? Because you're really concerned about the resale or the re-export by third parties or by intermediaries who aren't covered persons. And so the program addresses that specific problem in a couple ways. First, we can reach, if you're just talking about middlemen or proxies or cutouts or shell companies, those are all examples of evasion. And so we can reach any transaction that has the purpose of evading the regulations. That's prohibited, full stop. But absent that, legitimate transaction from a U.S. company A selling data to foreign company B that's in a third country, we have a mechanism that addresses that sort of resale or onward transfer problem. And the mechanism is this. The proposed rule says, U.S. company A, you have to do a couple things. You have to get a contractual commitment from that foreign third party you're selling to. There's got to be a restriction in the contract that restricts that third party's ability to resell or re-export the data to a country of concern or a covered person. So in effect, you could think of it as we're building a wall and we're saying, foreign third party, you're inside the wall, right? You're inside the trust. And this is really important because the whole program is built on the idea of trusted data flows. And so foreign third parties that U.S. companies do business with, if they're not a covered person, they're absolutely within the realm of trust. So but that's the contractual restriction is one way that we help enforce that. Another way we help enforce it is by having U.S. companies report to us if they ever suspect or they know that those foreign third parties are violating that restriction. If they're saying, yeah, thanks for the data, we're not going to resell this, and then turning around and reselling it, then then U.S. companies have to tell us. And if they tell us, then we can designate, and we mentioned that we can identify individual covered persons on this public list. We can designate that foreign third party if it's appropriate, and that would take them from inside the realm of trust to outside the realm of trust, and we treat them like a covered person. And so by doing that, we can create what we hope, we can help reinforce this idea that we're absolutely supportive of data flows with trust, and we get to help define who is trusted and who may fall outside of that.
Yeah, up until now. So before this executive order came into existence, was there any mechanism within the executive branch that addressed these kinds of national security risks, or no?
So it's funny, right? I mean, you've got two folks from the Foreign Investment Review section talking to you about data security. There's a mismatch between the name and what we're talking about. But there's actually not so much of a mismatch. The origins of this idea that we need generally applicable rules in some sort of new systemic program came from our experience in those other authorities. And so those other authorities are transaction-specific authorities. So instead of having generally applicable rules, it's things like the Committee on Foreign Investment in the United States, CFIUS, or Team Telecom, or a few other supply chain authorities that focused on reviewing individual transactions. What is the risk when this specific foreign company acquires this specific U.S. business, and how are we going to address that risk? There's a risk, great. We're going to reach an agreement with the company that mitigates that risk. They're going to have to implement cybersecurity requirements. They have to have a data security policy, and we're going to check on them, and they got to do an audit if we ask them to, and keep records and things like that. And over time, what we saw, especially the last 5 years, as this threat has really emerged and evolved, what we saw was, one, it's really happenstance that we're addressing data security in the context of a foreign investment. Data security problems also come up outside of foreign investment. And so that was just the happenstance of the authority that we were dealing with. And two, you start to see a lot of, we'll say, repeat risks and repeat mitigation measures across these authorities, right? Oh, it's another data security case. Okay, well, the mitigation measures typically, at their core don't change much. Maybe a little tailoring to the specific facts of the transactional business, but generally, data security policy, and you need a compliance program, and so on and so forth. So what we said to ourselves is, look, we're seeing the same kinds of solutions. We're seeing the same kinds of problems. Why are we still doing this on a case-by-case basis? And so we still have those case-by-case authorities, and how this program interacts with those authorities is important. We tried to design it, and I won't bore folks with it right now, but we tried to design it in a way where there won't be a lot of duplicative regulation or conflicting regulation or that sort of thing. But it's really born out of that experience of how those other authorities on a case-specific basis have reviewed and addressed those risks. And we've taken the lessons learned from that and helped turn it into an actual program that can address this more generally.
You mentioned last time on the show, how it was that DOJ got this gig, and it's basically because you're super good at corporate compliance, so it fits right in. And you also mentioned you're going to be expanding the foreign investment review section and hiring more attorneys, hiring more non-attorneys. Just one question is, how's that going? But then also, maybe as a more general matter, I assume you had broad interagency help in constructing this rule, people from Team Telecom, Commerce, DOD, FTC, but then DOJ is going to take the byline for this rule. Like, this is on justice.gov, not on some other website.gov. Does that have any impact on the effect of this rule or corporate compliance in general?
I'm sure. So first, to kind of back up, it took us 2.5 years to develop this concept for the executive order and now into the proposed rule. And, through that 2.5 years, we've had to coordinate with 24 federal departments and agencies, as well as White House offices, in order to build this thing and to, ensure that all of the equities within the executive branch have been, reflected in what we've put forward, right? So a tremendous amount of interagency coordination, for example, with CFIUS and Team Telecom and the ICTS team at Commerce, but also the CFPB, the FTC, the SEC, name the regulators that regulate certain portions of these commercial transactions or the data that's involved, to ensure that we've got it right. Also, continuous consultation with OFAC and BIS and FARA, where I mentioned we borrowed some concepts to make sure we understand how they work and how we make them as part of this program. All of that was baked into the 2.5 years question. But as you say, the byline is important. And to Devin's point, we are the Department of Justice, right? And corporate compliance is a big part of what we do. Enforcement is a big part of what we do. It's in the name, right? And so there's a reason that this ended up here, right? That combination of our expertise looking at this risk space, along with sort of the ethos of what DOJ is, I think actually make it a very natural place for it to end up, rather than, somewhere else within the interagency. And so, in the interim basis, as we try to stand this program up, we've also been building out a team within Fierce in order to basically conclude the rulemaking and to begin to implement, the requirements that are set forth there. And so we've had a, fairly quick build out of a team predominantly comprised of detailees from across the interagency to bring expertise together to help us do that. And so as of today, I believe we have 11 attorneys plus paralegals, targeters, and other support in place to start working through this. But they bring a range of that interagency expertise that we talked about. So we have an attorney here from OFAC, from FinCEN, from BIS. We have people here from the Department of Defense. We've covered a lot of the interagency that has stakeholders to have their expertise under our roof as we build this thing out. And so we're continuing on that path as we issue the final rule. I think we're hoping, by the end of the calendar year, we may have somewhere in the range of 17 people here. And that will form sort of the base of what this eventually becomes as a full-fledged team.
Where do you see this rule going or becoming? I mean, I think about the for example, financial industry goes really hard on compliance because they receive multi-billion-dollar fines. That's kind of par for the course. In contrast, these, for example, the chips export controls, this is sort of a new thing. The highest fine to date from BIS is 300 million from Seagate a few years ago. And the news which has dominated the export control land more recently is that a TSMC chip was found in Huawei, and the information a news outlet was able to figure out in about 3 seconds what the weak link in the supply chain was, which sort of begs the question: if some journalists could figure that out really quickly, how couldn't TSMC have figured out the same thing just as quickly? Chris Miller, for example, he said that chip companies need to focus a lot more, spend more on compliance, and governments need to enforce stricter enforcement with larger financial penalties for violations. So in the context of data security, where do you see this rule going or becoming in the future?
So look, I think, Matt Olson, who's my boss, the Assistant Attorney General for National Security, I think he said it best back in March. He said, look, the program will have real teeth. It has to have real teeth. Look, our first and foremost approach to this is through compliance, right? We want companies to understand their obligations. We want them to have programs in place to protect the data and to follow the rule and to comply with the security requirements if they're engaged in restricted transactions and so on. And we're going to work really hard to make sure that companies and individuals in the U.S. understand those obligations. That's the best that we can ask for. But if we have the situation where we have to enforce it, I mean, the penalties have to be real. They have to make a meaningful dent in the business so that there's actually a feedback loop that the business understands and internalizes their obligations. And I think more so than the amount of a penalty and how many zeros are behind it, what's really important for businesses to understand at the outset so that we don't have to have the penalty conversation is that compliance, and I mean this across, this is not just data security, this is CFIUS, this is Team Telecom, these are the other authorities that we are responsible for here. Compliance cannot be an afterthought. It has to be baked into the business process of the company, right? It's great to have a compliance program or a compliance team that's responsible for compliance, But if they're not part of the business making and business decision making process, then they're just throwing up red flags that get ignored or they get sent up after the fact. And so it's really important for compliance to be baked into the business process so that when the business is deciding, hey, should we open a new office in Shanghai and we're going to put our servers there and it's going to have, 1 million people's geolocation data on it and we're going to hire a bunch of covered persons to run it. That conversation cannot be separate from the, does this comply with the rules the US government has set out conversation? And that all needs to be part of the same business risk decision-making process. And that is what companies can really do. And part of that is, as Lee said, understanding, oh, okay, where do we have offices and what kinds of data do we hold? And what offices is it accessible from? And what safeguards do we have in place? And who has access? And by the way, who's on our global IT team and what kind of system level access do they have? And so on and so forth. And I think that's the real meat of it at the end of the day.
That all sounds about right. No, I think good lawyers like you are, you threw the kitchen sink at justifying this rule in statutory authority, Article 2 in the Constitution, Section 103, IEPA. So this is going to stick around for a while. But just on that briefly, do you think it would be better to address this risk by Congress legislating rather than through an IEPA executive order?
So look, IEPA is a very broad authority. It's intentionally broad. And in many ways, this IEPA-based rulemaking doesn't do much that's different than most other IEPA-based rulemakings. What does it do? It regulates commercial transactions. It regulates commercial activity that happens across borders. That's what any IEPA rulemaking does. And I think the program will absolutely stand on its own, absent any congressional involvement. And I think it's important it does. That said, look, I mean, we have had great partnerships with the folks in Congress in discussing ways in which certain aspects of IEPA can be clarified, for example, around the Berman Amendment, and even more importantly, in ensuring that we have the long-term resources we need to build out this program. And I know we're going to continue having those conversations, but what I think is a hopeful sign for me is that this is a risk where there isn't really any disagreement. I mean, it's a core national security risk that's been recognized across party, across administration, across Congress. And that's really what we're trying to address here. And so I think it will continue to be a national security priority across the US government. And I'm hopeful the program will stand on its own and continue to start to be a permanent fixture of the national security apparatus in the United States.
As per tradition, because you're repeat guests, we have song outros. You've already been through the ringer once trying to propose a data security related outro song. You want to give it another shot?
Yeah, I think not so much a data security related song, but one more about where we sit, which is we're thinking the theme from the Bad Boys show, from the show Cops in the 90s. The Bad Boys theme I think would fit us just right.
Perfect. We'll put that on. Lee, Devin, thanks so much for coming back on China Talk.
Thanks, Nick.
Thanks, Nick.